Hello, everyone, and welcome back to the channel. Hope you're all keeping well. And welcome to an episode looking more closely at the role of the jury and in criminal cases within England and Wales. Now, we had a few requests to look at a matter a bit more closely following a recent news story that a few of you may have come across regarding a chap who was a juror in Wales. And as you're probably well aware now, having watched the criminal litigation series, if you haven't watched any of those videos, do recommend you go back to have a look at those. In particular, Chapter 7, Inside Criminal Trial. So England and Wales cover the law for criminal cases in England and Wales, and they've got a separate system to Scotland and Northern Ireland. And we're just going to look at this case here. So I've got it on the screen here. So this is from 26th of October. This news story came in. And you can see here, the headline is "A juror was jailed after a web search halted a murder trial." So they're already going through a murder trial and suddenly the trial collapsed and they needed to halt it. So why was that the case? So we're just going to skim through this here. So a juror collapsed a murder trial after doing his own research on the internet, and he's been jailed for 4 months. He was selected as a juror in a trial of 3 people relating to a man's murder in Wales in December 2023. And this was based at Newport Crown Court in Wales. And the gentleman in question had sworn an oath. We did touch upon this within the criminal trial episode of our series of videos, masterclass videos, looking at the criminal case journey. And he had sworn an oath, and the jury had been given directions, which is normally the case, from the trial judge not to carry out their own research on the case. So normally at the beginning of a trial, the jurors are selected, 12 people at random from the holding room, and then the defendant looks at the jury and just lets the judge know if there is any potential conflict, if he knows any of them, or if he's got any, or he or she's got any concerns regarding the juror makeup. And the judge warns the jury as to the rules that they need to follow. Now, in terms of the criminal case, they need to just look at the evidence given before them. And you can see in this case here, the trial judge had obviously given that direction and that warning. So about a week into the trial, while in the jury room, he was overheard by the usher telling other jurors about a legal term called joint enterprise murder. So indicating that he had done his own research into this particular area of law. And as you can remember from the criminal litigation videos that we did, the Crown Court trial, the jurors are only there to decide on matters of fact. Matters of law is for the judge. So this gentleman should not be researching the law, should just be guided by the judge. As a result of this, the jury had been discharged and new jurors were selected. And you can see here, the gentleman's phone was seized for examination after he admitted he had found a newspaper article regarding the topic. So you can see here some mitigation there from the gentleman's lawyer. He had taken jury service very seriously and struggled with some of the legal concepts within the case. It's very important, if you don't understand as a juror a certain element of the case, normally what the best procedure is to write a note, a question on a piece of paper, and then ask the usher to hand it to the judge for clarification. And you can see here the judge's remarks: flagrant disobedience of the court's directions. It is normally very explicit that the judge gives these directions just to warn the jury. And had the usher not inadvertently happened to come across this, then potentially the other jurors may have been influenced by this gentleman's own legal research, and it may have been misleading. So let's look at some of the rules in general for jurors and dive in a bit deeper now. So you can see there, that the gentleman did state that he was not motivated by malice, and also that the responsibility of the juror, particularly in such a serious case such as murder, did weigh heavily on him. But there are very good reasons why people are told not to undertake their research, and we're going to go into that a little bit now to see how it could potentially prejudice the result of the trial. So let's have a look at that now. So when you're called in for jury service, you become part of one of the oldest and most important institutions in our justice system. So there's 12 ordinary citizens for a reason, deciding guilt or innocence. And this, as I said earlier, it's based only on the evidence heard in court. It must only be based on that. But that responsibility comes with strict rules, and the law expects jurors to stay impartial, to avoid any outside influence, and to base every decision only on the evidence presented before them. And breaking those rules isn't just frowned upon, it's now a criminal offence. So under the Criminal Justice and Courts Act 2015, the government introduced new sections into the original Juries Act 1974, and they created specific offences for misconduct by jurors. And we'll look at each of these offences now, what they mean, what can happen if they're ignored. So this is the big one, really. So no research. Jurors must never go online, read the news, or look up information about the case, witnesses, or the accused. So that means no Google searches, no street view maps of the crime scene, no checking social media, no digging into the defendant's background. Even if you think you're just clarifying something, it's still illegal. And Section 20A of the Jurors Act 1974 and inserting Section 71 of the Criminal Justice and Courts Act 2015 makes it a standalone offence for a juror to research a case. Maximum penalty, you think? Well, up to 2 years imprisonment and or a fine for this particular section. So the rule is simple: don't look anything up, however tempting it may be. Just make your decisions based on the evidence seen in court. Even worse than looking something up is sharing it. So if a juror brings outside information into the jury room by printing an article, forwarding a link, or even casually mentioning what they saw online, that's a separate criminal offence under Section 20B of the Juries Act 1974. And this is the one that applies in this case, in the Newport Crown Court case. So the law recognises that even sharing the material can poison the fairness of a trial. The judge might have to discharge the juror or the entire jury and order a retrial. Now, it seems like in the Newport case, because it's such an important trial, a murder trial, and the nature of the level of law that was divulged to other jurors, the whole jury was discharged. And the penalty is the same, up to 2 years in prison. You can see that our gentleman, he had some remorse and accepted the mistake he'd made and got 4 months. So if you're accidentally coming across something about the case, the correct thing to do would have been potentially telling the judge immediately not to discuss it with anyone, including other jurors. So what about other activity at home? You can imagine some cases are just one day. However, some more complex cases, such as the murder ones, can go on for days, weeks, even months. You've got time at home in between the court sitting within the day. So no experiments or outside prohibited conduct. Now this one might surprise you. Jurors can't carry out their own experiments. That includes timing journeys, testing sight lines, measuring distances, or asking friends on social media for opinions. Even if you think you're being helpful, it's still prohibited. Now this is covered by Section 20C of the Juries Act 1974. It's called prohibited conduct. It means you mustn't try the issue on anything other than the evidence given in court. And there's a famous example of the case of the Crown against Young, where a jury tried to contact the deceased via a Ouija board, to help them reach a verdict. So recommend you go, ironically, go and do your research online to have a look at that case. And it's very, very interesting, actually. And the Court of Appeal quashed the conviction. And ever since, jurors have been repeatedly reminded, decide only on the evidence you hear in court. So once all the evidence has been taken place within the trial, the jury are sent to a room to deliberate. Now, it's very important that jury deliberations are secret. And once the evidence is finished, jurors retire in a private room to consider their verdicts. Now, what's said in that room must never be shared. That means no talking about how people voted, no describing the discussions, and no posting or messaging about what went on. These restrictions apply during the trial and after it. They're there to protect the jurors, to keep verdicts free from pressure, and to ensure the justice system can function properly. The law does set this out in sections 20D up to 20G of the Jurors Act 1974. There are only narrow exceptions, for instance, where disclosure is allowed for investigations by the judge, the police, the Attorney General, Court of Appeal, or the Criminal Cases Review Commission. But outside of those, revealing deliberations is a criminal offence. So if you're on jury service, not to do anything that could put you in that situation. And today, most juror breaches involve mobile phones or social media, and it's not just limited to the jury. You could be sitting in the public gallery, and if you're not aware, someone may take photos. And photos, as mentioned on the last video, the walk-around tour outside the Crown Court and the Magistrates' Court. I did mention that I didn't go inside the court to extend the video because there are reporting restrictions and photo camera photography restrictions within the inside. And courts now have powers under section 69 of the Criminal Justice and Courts Act 2015 to restrict or search devices if there's any risk of their being misused. So in this particular case, if the judge was made aware by the usher about this gentleman who had researched the law, then the device can be seized to see what research took place. If a juror ignores the directions, they could face discharge from the jury, retrial, contempt of court hearing, and in serious cases such as this, prosecution, again carrying up to 2 years imprisonment, fines or costs. So here's a safe checklist if you are on jury service. Always follow the judge's directions and the usher, of course, but don't research or experiment. Don't post or poll anything online. Keep the deliberations private. And if you're ever unsure, just ask the judge. And these rules aren't designed to intimidate. They protect fairness, the accused, and the integrity of our jury system. Every juror's role is vital. And by following these rules, you help ensure justice is done and seen to be done. So hopefully that was just a brief insight into what restrictions there are for jurors in England and Wales following that recent news article that I was alerted to from some of the viewers. And as you can see, there are strict rules there. Again, just a reminder, if you are interested in the law, I have made a series of 10 videos looking at the journey of a criminal case from arrest and charge all the way up to sentencing and appeal. So go back and watch that. But otherwise, thank you for watching. Hope you do subscribe if you do enjoy the content. If you did want to follow to see more videos on the law and hopefully making it easy to understand, please do like and subscribe. If you do have any questions, drop them in the comments below. I'll try and answer all of them. Otherwise, thank you for watching. Hope to see you on the next video. Bye for now. Take care.